Good evening, everyone. Welcome. This is the Town of Somers Zoning Board of Appeals meeting. The date is June 13th, 2023. The time is 7:43. Denise, would you please take the roll?
Ms. DiPolito?
Here.
Mr. Gio?
Here.
Mr. Hardin?
Here.
Ms. Delansky?
Here.
Mr. Newman?
Here.
Mr. Padavani?
Here.
Chairman Canestra?
Here.
And I would just, for the record, Melissa is zooming in. Melissa, can you tell them about it's a medical condition. I don't want to misphrase things.
Without giving too much details, I would just say that it's a medical condition, if that's okay.
Yeah,
I think that's fine.
Right.
that's fine. Thank you.
That precludes you from attending in person here. Yes, that's fine. Okay. Next item, I request that everybody stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everyone. So we're going to go right into the agenda this evening. First item we have there on the agenda this evening is that of Joseph and Jennifer Whitman. This is an application to renew a special exception use permit as a new owner for an existing accessory apartment above a garage attached to the existing dwelling of a one-family dwelling in an R80 residential district at 9 Dr. Tony's Road, Katona. Is someone online or here to represent the applicant?
Yes.
Yes, we are.
Okay. Could you please give us your name and address?
Joseph Whitman and Jennifer Whitman, 9 Dr. Tony's Road, Katona, New York, 10536.
Okay. And as indicated in the application, you are a new owner to this property?
Correct.
Okay. And you wish to continue the special exception use permit for the accessory apartment in the at your property?
Yes, please.
Okay. Is anyone residing in that apartment right now?
No.
Okay. My next question is directed to the building inspector, Tom Tuma. Tom, have you been out there to inspect this apartment?
Yes, I have.
Okay. And is all in compliance and as indicated here on our accessory apartment checklist?
Yes, it is, and all's correct.
Okay. It looks like the accessory apartment is 361 square feet.
That's correct.
Okay. One bedroom. Okay. And sir, your lot size, your property is 8.38 acres?
Correct.
Okay. So quite a large property. Okay. Can the building department tell me if there's been any complaints or other issues in regard to this accessory apartment?
There have been none.
Okay, thank you. Any question from other board members regarding this apartment?
No, I do not. The only thing I have to say is it's very nice that the town has supplied us with this sheet of
Worksheet.
worksheet, and it answers a lot of questions. Thank you.
Yeah, I find it very helpful. This was really a good addition, Tom. Okay. All right, if there's no further questions of the board, maybe we'll open it up to the public. Does anybody online or here present wish to speak in regard to this application? Excuse me, anybody at home is welcome to call in utilizing one of the numbers in the white box, and then just put in the Zoom meeting ID number, and you'll come right on board, and you can ask us any question or make any comment you wish. We'll leave the public's comments on available for the next minute. Anybody here wish to speak in regard to the application? Nope. And no one online wishes to speak in regard to it? Nope. Okay. Anybody on the board have any further comments, questions? Last chance for,
No, I'm good.
okay.
One quick clarification. The 361, just on the worksheet here, it says 361 square feet is per the planning board resolution. But Tom, you said you confirmed that that matches up?
Yes,
Okay.
yes, and
great.
the planning board approved the original application for this accessory apartment. It was
Okay.
in their jurisdiction at that time frame.
Thank you.
Okay. Does the applicant have any further comments or anything else you'd like to say?
None at this time.
No, we don't.
Okay, all right, thank you. Okay. If there's no further comments, I think it's time for us to vote. Can I have a motion as to the type of action?
Type 2. Second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Mr. Padavani,
Aye.
Chairman Canestra.
Aye. Okay, we have a motion whether we're going to approve or not the special exception use permit for 7 years.
I'll make a motion to accept.
Aye, second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Mr. Padavani,
Aye.
Chairman Canestra.
Aye. Congratulations, your application has been granted. The special exception use permit is good for 7 years. After that time, you'd have to come back and reapply. Okay?
Thank you.
Okay, great.
All right,
you.
thank you. Have a good evening.
I will follow up with both of you. Thank you.
Okay, bye-bye.
Thank you.
Bye.
Okay, we're going to go to the second item on the agenda this evening. This is of UB Somers, Inc. This is an application for a height variance for a new business, Tractor Supply, sign in a community shopping district at 80 Route 6. And we have here to the applicant.
Myself,
I'm sorry, could you give me your name again?
Matthew Savage.
That's our same name. Okay. And you are the you're the
the
company
sign-
that is manufacturing the sign and
We're the
installing it?
sign installer. Yes.
Okay, okay. Could you briefly describe what's being proposed here, what you're requesting?
Okay, so we have the standard Tractor Supply logo. We do a bunch of these stores, from here to, the Northeast. And this is their typical layout for their store entrance, a stacked letters, tractor with a supply company underneath, and then their logo on the side there. The sign area in which it's going in, if we were to adhere to your 2-foot height maximum, and put them all on a line, the letters would reduce down to almost like 10 inches and would be very, very, barely visible. If we were to put them in a line or so. So we're asking for a 2-foot variance, so we can stack the letters and keep their logo intact.
And I see that you have provided us with a photograph with the sign imposed on the building. Is that in perspective, meaning is that the proper ratio of what the sign will look like on the building? Sign,
Correct.
bigger or smaller?
Yes. That is correct.
Okay.
So that, just to clarify, so the sign is about 16 and a half feet long, which would make that facade there something like 18 or 20 feet across, maybe?
Correct.
Do you know, do you happen to know exactly what the width of the facade is?
I didn't survey this one. They had this one already done. But I would assume you're probably correct in saying that's about 18 to 20 feet.
Right.
I would probably say closer to the 18 side.
And it looks like the size of the Blacklist Tractor Supply Company, they're 2 feet tall with maybe, I guess, 4.5 inches in between, right?
Yeah, right.
Right? That would make sense if the overall is 4 feet, 4.5 inches.
Yes.
Okay.
How far is it off the road?
This is quite a distance off the road.
It's inside the center. You can't see it from Route 6. You'd have to be inside the center.
Okay. I was assuming that that was the purpose to have the big letters, is because if you're driving by.
Yeah, I don't think you can see it.
You'd only see it from the parking lot. You'd have to be deep into the parking lot at that.
Yeah, this is where Home Goods used to be.
Yeah.
Okay.
So you have to go into the parking lot. The Chili's is off to the left
Right,
here.
right.
Yeah.
Right.
Are there any other signs on the building other than this one?
Yes. Yes, you have the strip mall. So I mean, you have a bunch of signs in there.
No, but I mean, is there any other sign, Tractor Supply Company signs on the building?
No. This would be this is their only sign.
Okay.
This.
Yes.
The two signs to the side, the garden center and the pickup, do those also say Tractor Supply as well?
No, they do not.
Oh, those are on those outbuildings you're looking at, Melissa, right?
Yes.
Yeah, I didn't notice those. Okay.
I mean, that's not part of this application. You should know, right?
No. We can look at it in the context of if we think it's too big based on the other signs on the property, but yeah, that's not,
It looks like they have the same thing on, well, they have a similar condition on the Goodwill, right?
Yep.
And a similar condition on the other one.
Yep.
And we probably approved those before.
I probably should make mention also, I think all of you have in your packet, there's a memo to the zoning board from the Architectural Review Board regarding Tractor Supply dated May 4th, 2023. It's a couple of sentences. I'm just going to read it into the record. At our April 27th, 2023 monthly meeting, the board met with Matt Kuzwich, of Matthew Signs to discuss a proposed sign for the Tractor Supply located at 80 Route 6. The height of the sign is 4 feet, 4.5 inches high by 16 feet, 6 3/8 inches long. The Tractor Supply logo is at the beginning of the sign, followed by a tractor on the top line and supply on the second line in black lettering on a white background. Although the board did not object to the design and color of the sign proposed, they could not approve this sign as it is 2 feet higher than what is allowable as code of Somers. The board does, however, understand the need for the height variance and agreed the area on the facade of the building where it will be placed can absolutely accommodate it. Did the Architectural Review Board, Matt, have any other comments in regard to the sign?
No, they did not.
Okay. I noticed it said on a white background. You're just going to put the sign on the facade as is. You're not putting a white background behind the sign, are you?
Correct. It's just going to go on the facade as is.
Okay.
Yeah, I mean, I think in this particular part of the shopping center, if you look at the small picture on the bottom right, you have the smaller stores which have sort of a different fascia there where they hang signs. This part of the building doesn't have that. If you were to put a smaller sign there, it would actually, I mean, that space is kind of made for a sign. It wouldn't look very good if you did it small. I don't think in that big space.
Right.
So I think it's attractive. And again, no one would see it that wasn't already inside the shopping center.
Right. And it is a large building, a large space they're leasing. You could almost theoretically, if there were several tenants, there could be a sign to the left of it and to the right on those facades too.
Correct.
So I
Yes.
think I don't see it as a problem.
I do not think it's going to impact the neighborhood.
No.
I think it's fair to say that it'll be congruent with the neighborhood and will have no impact on the street.
Right, right. Okay, any further comments from the board before we go to the public? No. Okay, does anybody here or online wish to speak in regard to this application? This is open to the public now. We'll take any comments. Once again, we put our phone numbers on the screen here, so anyone can call in if you wish to say something in regard to this application. We'll just leave this open for a minute or two. Any further discussion the board wants to have while we're waiting?
I'm good.
Good. Yeah. Sir, when do you think the sign will actually be placed on the building?
That's a good question. I don't have it yet, but I'm assuming it's probably when they're ready to open, we'll have it. So they didn't give me a time frame for it because they want to see if they're going to get approved first before they start manufacturing.
Right.
So I would say a month or two.
Is the sign illuminated?
It is illuminated.
Are these internally lit channel letters or is it an external?
Yeah,
They're
so they're internally illuminated channel letters. The face of them is a black perforated vinyl. So they'll look black during the day, and at night the light will light up through the holes in the perforated, and it'll light up like as a dull white, almost like a grayish color. So it's a very subdued light. But it looks pretty cool. I actually, my letters on my front of my building are the same way, and it just looks cool when you see it during the day. It's black, and then it lights up white at night.
And the TSC logo is also internally lit?
Yes.
Okay, so there's no exterior lights, no floods or spots shining on this thing. This is all internally lit.
Yes.
Okay. Okay. All right, last chance. Any further comments from the public? Anyone here wish to speak in regard to this application? Anyone online? Last chance? No? Any further comments from the board? Questions, issues, concerns?
No.
Sir, do you have anything to say in addition in regard to this application?
Nope, not at this time.
Okay. I think it's time to vote. Entertain a motion for the type of action.
Type 2. Second.
Ms. DiPolito,
I'm sorry, Melissa.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Mr. Padavani,
Aye.
Chairman Canestra.
Aye. Can we have a motion whether we're going to grant or deny the application before us?
I'll make the motion to approve of the signage as pointed to the board. Second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Mr. Padavani,
Aye.
Chairman Canestra.
Aye. Congratulations, sir. Your application has been granted.
Thank you for your time.
I'll
Thank you.
follow up, Matt.
Okay, thank you, Denise.
You're welcome. Thank you.
Okay. Bye.
Good night.
Good night.
Next item on the agenda this evening is that of Victor and Deborah Wu. This is a rehearing of an application for a side yard area variance for an existing in-ground pool accessory in an R80 residential district at 8 Silver Springs Court, Katona. Mr. Caruso, I assume you're representing the applicant here?
Good evening, yes. Good evening, how are we doing?
Good evening, sir.
Good evening,
Could
everybody.
you just give us your name for the record?
Of course, Michael Caruso, Cuddy and Fader for the petitioners, Victor and Deborah Wu, who are in the audience tonight. Good evening, everybody.
Good evening.
Good evening.
Now, as we're on the board's here tonight to convene a rehearing. Mr. Chairman, how would you like to proceed? We're here to inform the board, obviously. Let me know how you'd like to how we'd like to proceed.
Well, let me say this. We've heard extensive testimony in regard to this, have received extensive documents. If you to give some why I think the very big, I hear that. Also, I assume that you have seen the memorandum from Mr. Singleton dated May 30th, 2023. This is in regard to his argument that violations exist on the property and that we are not entitled to hear this application.
I have to be honest with you. I know there's a number of correspondence from Mr. Singleton's office. I don't recall. It may have been forwarded to me, so I don't have it handy. But
I think maybe, it's something I'd like you to address.
Sure.
So maybe I can give you some time again, Mr. Singleton.
Certainly.
Speak in regard to the point when we're available, but first I'd like to hear a synopsis. We can hear him and then you could.
And Victor, you mentioned asking him about a variance. Is that where we're starting?
I think that's where we're starting.
Because we were doing a rehearing on a couple of earlier points. We hadn't got to the variance yet.
Well, I think it was determined last time that we were, and maybe we should revisit this then carefully.
Yeah, I just want to make sure we procedurally we're where we are. Yeah. I'm gonna give Mr. Caruso a copy of the letter dated the 30th.
That might be a good idea.
Thank you. Appreciate that. I think I have this. And thank you, Mr. Lansky, for the letter.
The revote, but we weren't revoting on a variance. We hadn't gotten to the variance yet. Right.
Yes.
So we are.
Well, the last vote we had, okay. If you look back, everyone has the minutes from last meeting.
Right.
Okay. Let's take a look at this.
Said that Mr. Gladstone, this board didn't vote on the variance, therefore he would like to rehear the application. But the understanding that on the new materials, right? So this is a rehearing of the application.
Yeah, so there was a couple of arguments, I think, which were made regarding the application as to whether or not we could actually hear it as a variance.
Right, because the first motion that was made, Ms. DiPolito said the board has to delineate if the vote was a variance vote. With that in mind, a motion was made by Ms. DiPolito that the vote taken on April 18, 2023 was a variance vote, and therefore it should not be amended and revoted on. Mr. Newman seconded the motion. Vote was then taken by the board. The vote came down 4-3. The motion was denied. Mr. Lansky, you then made a motion that it was not a variance vote, but a non-action, and the application should be reheard. Mr. Harden seconded the motion. The vote was taken, and the vote was 5-2 that the application will be reheard on June 13th, with the understanding that the only new hard copy materials may be submitted to Ms. Shermer because we have all the previous. So I think.
So we're starting from scratch, I believe. We're going to vote. We'd need to vote on timeliness. We would need to vote on whether or not this was we had jurisdiction based on that duplication issue, and then move in. And then if it passes those two, then we would vote on the merits of the variance itself.
And I think that's what Mr. Singleton's going to address. And I would probably recommend that we let him address that and then give Mr. Caruso an opportunity. But I just wanted to clarify, because we never got to a variance. We were in what I'll call jurisdictional issues. And, I like to have matters heard. I just think that's better for the board and for the applicant. But I think we do have these issues were brought before us, and we were going to rehear them, not ad nauseum, but just the bullets we could.
So Mr. Caruso, what's your position on the items that we should be addressing this evening? I'd like to hear what you have to say about it.
Well, I'm going to be very clear as well. And there's no secrets, obviously, about this. My clients have challenged the April 18th action of the board and have taken that challenge under Article 78 of the CPLR to the Supreme Court, Westchester County. So that action that really is examining the decision-making on procedural and merits grounds is in front of a court now. We are here to inform the board. As I advised Ms. Skirmer, we're not submitting new materials for a rehearing. Our position is that the board acted on April 18th. Nonetheless, we're still here. Obviously, the board has convened a meeting. We're here as the applicants to inform the board to the extent this rehearing is the chosen course. So tonight, my intention is to just brief the board again on our position on your jurisdiction in simple, in brief terms, field any questions you have, and I'll address what I can in this May 30th letter as I'm reading it.
Because we have received nothing from any court to hold up the application at this point in time. So
right,
we're proceeding forward until we have an order that says that we can't proceed.
Right. And my clients didn't seek a stay in the Supreme Court, trying to prevent this board from moving forward with whatever course it sees to be appropriate through the advice of counsel. So, I'm trying to convey to the board is I'm not trying to speak out of both sides of my mouth here. We felt there is a legitimate, proper challenge to the April 18th meeting and the events and the vote. We're also here to inform the board and participate as the applicant and do what we can to help guide you and inform you. So that's what I'll do. So if you like, I'll take you through the jurisdictional points briefly. I know we've really hit this extensively. I'll try to keep this 2 minutes or less. I promise.
Thank you. Yeah.
So there's been a lot of discussion about how we got here, what were the circumstances. As the board knows, violations were issued in 2021. There was a plan of action by Mr. Toda, who was Wu's prior attorney. And just, at that time, I think there were a lot of discussions happening with Jerry Riley's office, Mr. Singleton, Mr. Toda, as to how to resolve this very unique and challenging situation while the violations had issued from the town. So there was, I think at that time, not a clear course. My conversations with Mr. Toda have informed me that I believe he was directed to pursue settlement as aggressively as he could. And that's always the preferred course for the parties to figure this out on their own. That being said, it wasn't successful. So when my office got involved after Mr. Toda, how we got here is there were pending code violations that were in the Somers Justice Court that were resolved. Now, in this letter, Mr. Singleton's taking issue with whether those still constitute violations. I appeared in front of Judge Timone. We conditionally resolved those violations. Yes, by taking one guilty plea to one of the charges and accepting an ACD on the second, or a CD, a conditional discharge on the second, so that the Wus would clean up and get rid of whatever encroachments had been put on the Stanciu property inadvertently, which they've done to 95% completion very quickly after that court date. So that was on Halloween of 2022. There's only one remaining step to finish, which is to remove fence posts that were cut when the Stancius just ripped their vinyl fence down. So we've asked 4 times to get on the property. We haven't been allowed on. That's the only thing we need to do to satisfy what the court has told us to do and what we agreed to do. So our position is that the violations that came from the town in 2021 were conditionally discharged. They don't present current violations. And we've satisfied, to the best of our ability so far, within that 1-year period, what we needed to do to resolve those. So the question before you on your jurisdiction is, am I here on behalf of my clients on the same application as what happened in 2021? So Mr. Toda's office withdrew that application. The board discussed it and asked him, is this what you intend to do? He said, yes. Mr. Chairman said, your application is deemed withdrawn. And I believe Mr. Lansky said, that's deemed a legal nullity. I agree. That application did not mean anything after that point in time legally and for this board's jurisdiction. Fast forward, after the town code violation issues were resolved through my office, Mr. Tuma's office, by my request, issued a determination on the C of O application for this pool. And Mr. Singleton has said that's really nothing different. But what your code said is there is a determination that is issued that can be challenged. That was a determination of the building inspector who's charged with interpreting the code. On October 25th of 22, he said, I'm denying your application. Within 60 days, which the board and I discussed, on December 23rd, I filed this variance application. Here we are. So there is no prior application, if you will. What Mr. Toda withdrew and what the board allowed him to withdraw was a 0. It doesn't bind this board. It's not a prior determination. There's no duplication. This is its own standalone application. That's what your code says. That's why we're here. The timing of that application is crystal clear. October 25th is when the decision was rendered. We appealed it to this town on the 23rd of December. We amended it in February to provide better engineering schematics. That's our application. And that's why you have jurisdiction to hear it.
Okay. May I?
Yes, sir.
Sure, absolutely. Go right ahead.
I think this was kind of, Tom posed the question before. And so a violation is issued. You have a statutory period of time to appeal to the ZBA. You appeal within that time frame, and then it gets withdrawn and it becomes a legal nullity. So that initial application, you've now no longer met that appeal date, right?
Correct. We never contended that that was a timely appeal or there could have been a timely appeal at this point in time. That's history.
So the crux of the matter for the board really is the materially different question.
Correct. So what happened between when, sorry, Mr. Lansky.
Yeah.
So once that application was withdrawn, we asked Mr. Tuma for a decision on our pending C of O application tied to the pool. He rendered that decision in writing on October 25th of 22, 5 or 6 months after that application, the first one was withdrawn. So that is our application. It's based on his denial saying, you are not allowed to have a C of O. You need an area variance because you're violating the side yard setback based on the placement of your pool. That's our application.
So
If I recall correctly, we voted on the timeliness of the application before, and I think we all agreed that it was timely.
I agree.
Then we got to, is the application materially different?
yes,
And that's where we got stuck. We were 3-3
yeah.
with Paul not voting. So the idea was, were we going to rehear it and re-vote on it again?
So
And that has been determined that we're going to. So
Yeah.
I assume that we should probably go through the timeliness vote, the materially different vote, and then depending on where that comes out, entertain the variance.
But I think we're really, what I'm saying is really, this boils down really to whether it's materially different. So whether or not that initial determination from the building department that the pool didn't meet the setbacks, and that everything else related to that, whether this new determination, which is with regards to a CO, but it still has the same underlying pool, the same setbacks, whether that's materially different. And I think that's the crux for, and I know
Materially different than what?
than the first application.
That is now. So if the argument, which is that application is a legal nullity, as has been suggested, I have nothing to be materially different from.
But that's what
So I'd like clarification.
Yeah, that's what I was trying to distill with Mr. Caruso, and I'm sure Mr. Singleton will help us in a minute.
Yes.
We'll get to him in a minute. Is that that first determination still exists, even if the application, which was made to us, becomes a legal nullity,
Or even if it was never made.
or even if it's never,
The
well, there's a determination made by the building department, that doesn't become a legal nullity.
Right.
Their application to us becomes a legal nullity.
I think,
So different, materially different from that to this determination and this application.
but it's also not just, and forgive me, Mr.
No,
Plansky, it's not just whether this is the same relief we're seeking. So that seems to be a hangup. Why are we here on a different application potentially looking for the same thing? Are we just putting it in different wrapping paper? The answer is no. And the reason why is this board has never determined our whatever prior application that was withdrawn was withdrawn. The board has never spoken to it. It's never considered it. It's never decided it. So whether it's identical or not, or how it came here, you've never hit the merits of it. That's why we can bring the second application. If you want to call it a second one, I would submit that this is the first one. And the first attempt was an attempt that was withdrawn. The board heard it. It polled the board members and said, what do you think? And then Chairman Canister said, you want to withdraw? Dan Tota said, yes. End of story.
I mean, I understand the two arguments.
Yep. So let's have Mr. Singleton weigh in.
And the timeliness also is timeliness from the denial by the building inspector of your application for a C of O.
Right.
That's because that's different from.
But I just want to be clear, though, the fact that perhaps all of this may have sprung from, and I'm going to give, the mic to Whitney in a second. The fact that it may have sprung from a violation in 2021, I think what the board needs to focus on is not that violation must have come through the channels to this board to be finally interpreted and resolved by an area variance. The channel it took was to the Justice Court, where it was then conditionally resolved. A STIP was prepared. Judge Timon signed it, and it was signed by the parties, including Jerry Riley on the prosecution side. That resolved that. That's done. That's in the history books. It is not coming back to this board. So the fact, I think the board needs to just and I knew I was going to draw that comment, but the point is there is an end point for that violation. It's been met. And now we're here challenging a determination of the building inspector, which is what the code says we're allowed to do.
Let me just make one other mention here. I did speak with town council today about this specific issue. And town council felt that there is not a pending violation at this time. You have, I believe, until October 31st to resolve it, but there has been a decision, so to speak, on this. So there's not a pending violation. That was Mr. Riley's position. I certainly want to hear from Mr. Singleton. Should we go to Mr. Singleton?
Yeah, I'm glad to leave
Okay.
the floor here.
Please comment in regard to this.
First of all, I mean, there's a lot to unpack there. First of all, I want to kind of cut through what vote you were on. You had voted as to whether or not this was a substantially similar application. It was a 3-3 vote, which is either a non-action or a deemed denial. Mr. Caruso has sued your board based upon, or the Woos have sued your board based upon that denial, and is currently pending an Article 78 case for which motions to dismiss will be made. Secondly, with regard to, and most importantly, with regard to the current application before your board, it is untimely, unquestionably untimely. If you look at your own code, and I'm not paraphrasing, I'm going to read, simultaneously with the filing of an application to any board or any official of the town of Somers, an applicant must submit proof using the certification form attached here to that ... there are no outstanding violations of any local law or ordinance. There is an outstanding violation of a local ordinance, and your code goes on in enormous detail to say how your board has no jurisdiction to hear this case. I gave you a very elaborate memo which sets forth all of the requirements, none of which have been met. Did Mr. Caruso's client submit a certification form with their application on December 23rd that there were no violations on the property? They didn't. plain and simple. Now, with regard to what is a violation and whether it's in the past, it's history. And respectfully, I'm very surprised with Jerry Riley's position on this thing. I've given you the law as to what a conditional discharge is. A conditional discharge is not an elimination of the violation. The violation continues to exist. As I pointed out on page 6 of my memo to you, under both the penal law and the criminal procedure law, a conditional discharge continues to be a violation on the property. They pled guilty to a violation. The local justice court didn't say go remove the fence or the wall that you put on the stance use property. What the court said was you needed to correct the violation. The court's acknowledging that there's a violation, and they gave them a discharge of the penalty if they resolved it by October 31st, 2023. There is no way in the world that you can say this violation does not exist. That's a fool's errand. And there's no way in the world under state statutory law here, the criminal procedure law and the penal law, that you're going to argue that there's no violation on the property, that it's in the history books. That's a complete falsehood. If you want to take that position, I'm happy to bring that to court. There's no way in the world that you can't say that there's a violation. They pled guilty to a violation. The violation still exists today. The fact that there is no penalty, that there's a potential for the penalty to be waived if they correct the violation, that has nothing to do with whether or not there's a violation. And your code is exceptionally good in detailing what your board's lack of jurisdiction is in this case. Your board needs to determine that the application is not timely because they did not submit a certification form to you setting forth that there are no violations on the property as required by your code. Your board needs to make a determination that you have no jurisdiction to hear the balance of the case, and you need to dismiss this thing tonight. And anything beyond that is further litigation.
Mr. Singleton, our attorney.
Mr. Lansky, you have lobbied so hard for this applicant. It's unbelievable. I can't even believe we're having a discussion. These people built things on my client's property. They destroyed my client's property. They trespassed and then kept them off the property. And the town has done nothing. The no as-built survey, no inspections to require that everything was done according to Hoyle. No, it boggles my mind that Mr. Tuma reissued a building permit in violation of Chapter 67 when he knew that the pool was not built in accordance with plans.
Mr. Singleton, right?
This is like kangaroo court here.
Mr. Singleton.
But we're here for a rehearing, and he's bringing up new questions of law.
You asked me to bring up new items. That's what my letter specifically stated. And your board should have known that you had no jurisdiction to hear this case. You wasted $40,000 of my client's money going through this process for the past 2.5 years, when the building department and the engineering department should have made sure that none of this happened to begin with.
Mr. Singleton, let me say this first. Town court has already looked at the matter and has stipulated that it has to be resolved by October 31st.
Correct.
So to say that the town has done nothing, I think is wrong. Also, when we had a vote and the vote was 3-3, you said that was automatically a denial. And upon further research, that is not true. It is not a denial. Okay, it's a non-decision, and that's why we're here. So,
Chairman,
I'm not really interested in lobbing grenades at each other. Okay, we're trying to resolve the issues here.
Chairman, can I respond to the specific issues?
Sure.
First of all, it's not really fair to say that the town's done something. What the town prosecuted, and now they're going to say, okay, forgive us for building in the wrong location. Forgive us for doing all this damage to the stance use property, and give us a variance to build right up to the edge of the property line.
Well, we haven't granted a variance yet.
No.
I know. I mean, this is pending matter.
Nothing. All right. With regard to the other issue, I'm sorry. Can you just repeat what the issue of the vote? I agree with you, and I agreed with you at the last meeting. Go back and look at Go back and look at the video. I agreed that the determination that you were making at your last meeting was not ultimately on the variance. I concurred not only with your board, but with Jerry Riley's interpretation. What happened, though, is that's not what Mr. Caruso believes. Mr. Caruso believes it was a final determination, and that's why he's suing your board. You cannot sue a zoning board or a planning board or anyone else until there has been a final determination. And that's why his lawsuit is going to be thrown out, because you didn't make a final determination. I'm coming to you with something completely different. I'm telling you that there's a violation on the property and your code prohibits you from entertaining this application. It prohibits Mr. Tuma from issuing any permits or certificates or anything else.
That's not what we're
until
here
that
for.
violation is corrected.
Well, I mean, just so you know, town council doesn't agree. They do not believe, the town council does not believe that a violation currently exists on the property. I'm just giving you his point, and we will have to decide. But one thing I will say is, I may agree with you that, a final decision was not made. So I don't know that the Article 78 proceeding will be successful. It may very well not be. And that's probably our position, but that's a separate issue. We're not here.
I mean, if somebody pleads guilty to a violation on their property and they don't remove it, how can you say it's no longer a violation on the property?
Your client stood in front of us and said that they were going to let.
Michael, you had your chance. You had your chance.
Sir, let me finish. Your client stood in front of us and said they were going to let the Woos come on the property with their agents and remove the remainder of the fence. They sat here and said that. And you're saying the violation still exists and they haven't let them on the property to remove it.
Mr. Lansky, with all due respect, this shows that you're not understanding. You're not understanding what the violation is. Who's speaking?
Your client.
Okay. Panta, sit down. Panta, sit down.
Yeah. Okay.
All right. Mr. Lansky, the fence has nothing to do with the violation. The wall has nothing to do with the violation. Yes, they trespassed onto my client's property. They did extensive damage to my client's property. They ripped up all the drainage, which you guys haven't even addressed yet. They have done all sorts of damage to my client's property. The violation is that the pool is too close to the property line. That was the application before, time barred. That's the application now, time barred. And that's the violation, which takes all jurisdiction away from your board. I honestly think that you need to confer much more closely with counsel. I have tremendous respect for your counsel, but on the issue of whether a violation currently exists, did you provide him with a copy of the memo? The criminal procedural law and the penal law are very clear that a conditional discharge is solely relates to the penalty, not to the underlying violation. The violation does not get removed until the condition has been met, and the condition has not been met. He hasn't removed the violation.
We're still here for a
and Mr.
review
Caruso,
on-
you had a lot of time up there. Please don't interrupt me.
He hasn't
Your
said any-
board, your board has zero jurisdiction in this matter.
So can I just insert a question for Mr. Singleton? So I understand, so there's a discussion here about whether or not the violation still exists.
Yes.
So I don't know.
There's not an issue. It's clear.
There's a debate, clearly. So is it correct that the Woos are unable to fix that condition because they're not being allowed on the property? Would you say that's an accurate statement?
That's an accurate statement.
That is a red herring.
I gotta ask him.
Nothing to do with this has nothing to do with going onto the Stancia property. It all has to do with the Woo property and the violations on the Woo property.
So my office has asked Mr. Singleton's office 4 times in writing, to Mr. Lansky's point, to Mr. Newman's point. Since we conditionally resolved those violations in the Justice Court, my clients performed the work within about a month, almost all of it. Since that time, removing the cut fence posts, I've asked Mr. Singleton 4 times in writing. I'll give it to you. I have not even been given a response. His client stood here and said, come on the property, get rid of it. If his argument is that there's a violation because we're dragging our feet.
No,
sorry,
no, no,
that's
no.
just not
I understand. I understand, Mr. Singleton's.
That's not my
violation.
argument.
The violation that he's referring to is the pool.
Right.
It's not, nothing to do with this.
That is, but it's also a bit of bad faith.
Right.
Sure,
Why has
but
that
sure,
not-
but-
Whoa. What do you mean bad faith?
Why has that not been approved?
What?
Why haven't you let them on the property to fix that?
Because I waited a year and a half for the Woos to respond to me and they wouldn't respond. They wouldn't let us onto our property. Forget their property. They wouldn't let us onto our property. So
As long as we know it's
I don't feel any compulsion on behalf of the stance used to allow further trespassing by the Woos. The issue of the fence, first of all, your board only has jurisdiction with regard to the Woo property. It's the only application before you. Whatever's going on with regard to those fence posts that were illegally placed on my client's property is irrelevant. If you want me to read, and it's an attachment in the package I gave you, go to the stipulation that was in there. They pled guilty. They enter a plea of guilty to section 170A1 zoning setback schedule. They pled guilty to a zoning setback on their property, not on the neighbor's property.
Yeah,
Your
I think
board's
we're
not
all
gonna
agreed.
take
We
the
don't need to talk
application
about the encroachment, right?
No,
It's right.
It's
Let's move on.
This-
What Mr.
your
Singleton
board-
is saying that the violation is the setback of the pool. The pool
Correct.
is only 3 feet from the property line. It's supposed to be 15 feet. So it's the violation of the setback.
That's
Yep.
correct.
Okay.
Okay, just so we understand what the topic.
That's correct. Everything else
I
is
thought
just a
that's
red
what we were
herring
getting
discussion.
together tonight to talk about.
Well, yeah, I mean,
We're having a rehearing on this first thing and then to see if it gets to whether or not we're doing it, right?
And
now,
I'm
Mr.
telling you,
Singleton
your
is bringing
board
up a
has
new
zero
issue of a
jurisdiction.
violation pending.
But that's not what we came here for. And
kind
that's
of a
not
new-
what we're,
it's a kind
that's
of
a
a new
whole
topic.
nother line of inquiry.
It's a whole nother new topic.
And the advice we have from our town attorney is that there is no open violation. So. And that's not what the notice that was given, and that's not what the applicants came here for.
With all respect, what difference does it make what the applicants came there for? Look at all the
It's our
damage and cost that they
application.
cost our client.
Come on.
This is absurd. Your board has no jurisdiction. If you want to vote, vote. I'm telling you, if you vote, I'm suing you for adopting an action in violation of your jurisdiction. And I'm telling you that a conditional discharge is not elimination of a violation. It specifically means that the violation continues to exist.
But there's no
discharge is a
conditional
penalty.
discharge for the pool, correct? The conditional discharge has to do with the encroachment. We're not talking about the encroachment anymore.
Yeah, but no, but hold on. The conditional discharge is from the initial violation letter,
Right.
which I do not understand, but I imagine that the setback.
It's a boom is there. That's precisely what it says, and I can read it to you verbatim if you like.
Yeah, I just don't have it.
I can locate it.
It's for the setback.
I understand Mr. Singleton's point. That's not the issue. And frankly, threatening to sue us, there's two parties who are very aggrieved. One of them's going to sue no matter what we do.
No, that's not true.
I don't know what we're supposed to do with that.
Yeah,
a threat of a suit
isn't going to change our opinion. I don't know. So,
I think we have, an initial
Zero
pick to decide.
jurisdiction.
Right. We were deciding jurisdiction based on other criteria last time.
Yep.
And now one additional criteria has been added,
this is the first time we've heard about
which is that even the application that the application didn't include the certification of no violation.
Right. Which it's required to.
So
You have 8 different ways to Sunday that you can
And
reject
the
this
board can
application.
waive that strict compliance as he's cited in his letter. So that's up to the board. If the board feels that we've come here tonight lacking something which we weren't aware of, we'll happily correct it. I think we've briefed that issue in terms of what the violation was, where it currently stands, and what that means. I think the board has a good enough understanding of that through their own attorney as well. So If there's some strict compliance issue with an application requirement, again, the board can waive that under 67-5. It's up to the board.
You're supposed to have a complete application submitted within 60 days of the denial. You don't have one. The board does not have the jurisdictional authority to extend the filing period. I've briefed you on this. You
Well, if
have,
you want to
I made a
truly-
mistake.
If you want to
have
split
20
hairs
different ways
here,
to reject this application.
that's wonderful. The only thing the board needs to be concerned about is what it's been briefed on and what it has in front of it. I think the board has enough to reasonably make a determination. I don't think the two of us lawyers fighting is going to make any impact on the board. I think the board is well-versed and can do its job. I don't think we need to tell the board how to do its job.
Well, that sounds nice, Michael, but the fact of the matter is the board should be fully aware of what jurisdiction they have and don't have.
I think they are, Whitney. I think they
Your
are.
board has tremendous discretionary authority. It has absolutely zero ability to alter your jurisdictional authority. And that's really, quite frankly, Chairman, that's why this whole thing's been going on. The town's done nothing to protect my client. So every discretionary item, I've had to fight you on tooth and nail, but for some reason you deem to be a 98% variance from the setback to be a new application, even though it's based upon the same building permit. So I've had to render this application to find a way to take jurisdiction away from you because there's been so much bias in favor of the woos and to the detriment of the Stancius. The Stancius.
I don't know how you can make that determination. The board hasn't voted on those items.
Oh,
And actually, we had a split vote last time.
From day one.
I
think that's very unfair to say that of this board. I think the board has done a very good job of being objective here.
Completely wrong.
Yeah,
I think that's very unfair to say of the board.
that's very unreasonable, Mr. Singleton. I don't think that's the case at all. I think we try to be open to the applicant and those who might be on the other side. So
I think that the town has done a negligent job by allowing the pool to be installed in a location without any surveys being performed to show the setbacks, as-built surveys. I think that the engineer has done a terrible job suggesting that a certificate of occupancy should be issued for improvements on my client's property. I think that the woos have either done a terribly negligent job or an intentional job to take land from my clients. And I think it's your board's job to protect my client. Why should my client have to spend $40,000 to advise you of your jurisdiction and your obligations under this application? I'm not trying to be argumentative with your board, but this has gone on way, way too long. And for you to read chapter 67 and say to yourselves that you still have jurisdiction, that to me, I don't know how any reasonable person could say that you have jurisdiction after reading chapter 67.
I mean,
It's a requirement of the application that he submit this certification, which he did not do.
town council has a direct opposite opinion from yours, that there is not a pending violation and that we hear this and rehear the matter. So I mean, you can't speak with,
and we're having a discussion, right? We haven't rendered any decision. We haven't come to a conclusion about jurisdiction. We're trying to have that conversation. And each time we try to have that conversation, Mr. Singleton, you're complicating. You're stopping us from having that conversation by arguing and threatening lawsuits. So I think it would be good if the board if you could help possibly facilitate, that would be good. But we haven't made that. You're accusing us of making a determination that we haven't made yet. We are trying to have some conversation and debate about it.
I do appreciate the deliberative nature of it. And yes, I am throwing up roadblocks for you. I'm trying to find anything in the world for your board not to vote, because I think it's an atrocity. And
but all these things are taking a lot of time. I mean, we may have voted on this several meetings ago and maybe granted or denied the variance. I mean, I don't know how it's going to come out, because nobody, I don't think, has really made a decision on that yet. We've only trying to determine, are we going to hear this matter? Was it timely? Was it materially different? Now we're talking about violations. All these things are not delays from the zoning board. It's delays from the parties here arguing on both sides. That's where the delays are coming from. Because to take my word for it, we'd like to get this resolved. There's no question about it.
And I
Mr.
just think
Singleton,
this is a massive injustice to the stance you.
you've suggested that this board and myself have bias.
No, I didn't say that. I said you had bias, Mr. Lansky.
How kind.
Yeah, I do have a bias. My bias is to hear an application. I think the law has that same bias. I believe that having things heard in full rather than working on them on jurisdictional grounds, that's what the law favors.
Now, the law favors, and it's from the very first submission that I gave you, for property owners to have repose in the ownership of their property. The stance used should not have had to deal with this for the past 4 years. The town should have gotten it right from the beginning.
Or they could have walked outside when the machines were there and checked their own survey. Like that's you're saying the town had that responsibility. We had that responsibility. The town your client lived in the house.
I think
all
one thing
towns
that
require as-built, don't they, Mr. Tuma?
I think the board is.
We're just arguing now.
I think the board is interested in getting to a decision point.
Because
So
I thought once you saw this memo, this case was over. I can't believe we're having a discussion on it.
Who would know with you arguing whether this case is over or not? We can't get to a way to bring something up because you haven't. Every time we even go to maybe not vote on it, you've stopped us from doing that.
I think, Mr. Padovani, this might help the board. And I'm just going to pass this around for facilitating some thought here. All the legal issues that are out there, all the roadblocks, whatever they may be, this board is here to do a job. It's here to do a job fairly. It's here to apply its code. We're not suggesting otherwise. I'm going to show you a photo that reflects what would happen if this pool is to be dug out of the ground and moved 3 feet. This is what we're fighting about here. This was not intentional. Trust me.
Why are you saying 3 feet?
3 feet. I mean, 12 feet.
Well, no, hold on. Look, this is the amount the pool would need to be moved.
Now,
Because there's a 15 foot setback.
How much is that? I'm sorry. How much is that? Okay, so I'm sorry. Whatever this reflects, it's not to scale. So this is 7 feet, whatever the scale may be. I want the board to just look at this.
Now keep in mind, so we're clear, my understanding is that there's a 15-foot side yard setback here, and you are 3 feet from the property line. So there's a 12-foot.
This is 12. I'm sorry. So this isn't quite to scale, but what I'm trying to refocus the attention on this is a photo that my clients took. It's an aerial photo. Again, it's
the scale.
It's the
scale.
Using that.
Yeah, it's not.
I just want the board to see if the pool were in compliance, what would this look like? Right? If the board were to say, we're fighting up the mountain.
See this? Can I just hold it up? Can I just hold it up? Can you focus in on it? So what I think we're looking at here is the straight line is the property line, and then the red line would be where the pool would be moved to.
Right.
If it were to meet the setback.
Yeah.
I give that to the
I
board
object
just
to
for.
the submission of that photograph as being evidence of actual setbacks.
I'm just showing this photograph to put things in perspective because we've wasted a lot of time with the board.
Right. I mean, it's an aerial.
I'm putting this in front of the board only to establish that if this thing is ripped out of the ground and we move it X distance, that's what it looks like. That's what this war is about. We're not here because we put this there intentionally. Quite the opposite.
Right. We understand. This is about 12 feet of setback. That's what this is about. We understand.
But to be clear, there was a survey. There were pins in the ground. They were ripped out so that the pool could be put in. The 15-foot setback was shown on their property in their survey, and pins were placed physically on the site, and the contractors ripped them out and built the pool in the setback. So
Again,
I
just
don't
show
believe
the
it's as
photo for
innocuous as you think.
Right.
That's it.
And I do recall that point being made by you, Mr. Singleton. So.
And coincidentally, if there was such error by the surveyors, why did the lawsuit go nowhere against the surveyors?
We didn't.
Yeah, well, I tell you what, I don't think we need to hear that.
You know,
Okay.
on with.
over that.
Can we have an internal discussion and?
That would be great.
Yeah, why don't we have a discussion right now with any further comments
Yeah.
from the people? And I want to open this up to the public also, because this is a public hearing. So maybe we should do that first. To see if there's anybody online. Does anybody here in the public?
Well, we know what public we have.
Okay. All right. Why don't we talk first, then we'll let them.
Yeah, I mean, I know what they're gonna say. I don't know if you want to hear, check online.
Okay. I mean, I would say also, to repeat the same information that we've heard the last meeting or several meetings. We've already heard that. So, if it's something new, I'd like to entertain it, but I'm trying to not go over all the old material because we'll be here all night. So yes, let's go out to the public. Does anybody wish to speak in regard to this application? If so, you can please call in on one of the numbers in the white box, put in the Zoom meeting ID number, and then we're willing to hear what you have to say.
Meanwhile, we can talk.
And we can talk while someone is calling. So
Guys, the bottom line is the pool hasn't moved.
Application.
Yep. The pool is where the pool is. I mean, I think.
It's just.
Okay, so I mean, is our vote this evening, or what we're going to talk about are we going to revote this? Is it number one, is it timely? Is the application materially different? And if we get past those two hurdles, then we would vote on whether we're going to grant or deny the variance.
Since we're doing a rehearing, I was gonna pull up the old minutes and see what our exact vote was before, which went 3-3. And then use that as a basis. Do we have that?
We have that. Let me.
Because I believe the minutes. No, it's the former minutes.
It would be the,
Former minutes.
yeah, it would be March.
March,
Okay, I got them.
Or March, April
April, probably.
April minutes,
April.
right?
April.
Right, because we did
I can
May,
get that.
April.
Minutes were approved. Timely manner.
April.
Because our
Okay.
because we voted on last time whether there was a variance.
Okay.
Okay, so one,
We wanted to hear more.
because that's when we voted on the timeliness of the application and on the materially different aspects.
So the application was that I made the application.
Okay.
And it was a motion to
You made
hear
the
the
motion.
application because it is materially different.
Right.
And then we went 3-3 on that. But we didn't further elaborate on that.
Right, but now the previous to that, whether it was timely, there was a vote right before that.
That wasn't,
But that passed.
we're not rehearing that.
No, I-
We're only rehearing the tie.
Right.
So the tie vote is 3-3, and the motion which was made was that it's materially different. So
Right now, if it's materially different, then we can go to the variance vote. If it's not materially different, then we can't go to the variance vote, right?
yes,
Now, the previous vote to that, whether it was timely, I believe it was 6-0 that it was considered. So we all considered, one member missing, we all considered it to be timely.
yep.
And then it's whether it's materially different. And then 3 of us voted that it was materially different. 3 voted it wasn't materially different. I guess a member could change their vote.
So I would suggest that we have a little discussion about materially different, whether or not we want to add anything to this vote, or that we just want to keep it as simple as that and then revote it.
Okay.
Because unless there's other things we want to hear about it.
Yeah. While we've been talking, Paul, has anyone come online that wishes to speak in regard to this application? No, we have nobody from the public wishing to speak. Okay. I mean, I should open it up here. Well,
So, again, so we don't have any specific advice from counsel about the legal nullity question, do we? Do we have anything
talking
specific about that?
whether it is a pending violation.
Whether the withdrawn application exists?
Well, this goes back to, I think, whether it was timely, and we voted it was timely.
Mhm.
So,
No,
I mean,
you voted it
it's not that you may change your vote. I
No,
mean,
we're going to do this ourselves,
No.
Mr. Singleton.
Okay,
Thank you.
sorry.
okay, so we as a board, 6-0, did vote previously in April that the application was timely.
Based on the new CO request or the new CO denial.
Right, and, right.
And the assertion.
And it being withdrawn previously. That was our position. We didn't really go to legal, well, we didn't really discuss it with legal counsel, that matter. We decided we were going to decide that as a board. And then the second vote we had was, because the second hurdle to get over before we vote on the variance was it materially different? And that's where we deadlocked. 3 of us said it was materially different, which means you can vote for the variance. 3 said it was not materially different. But to me, if we agreed it's timely, I'm not sure. That's why I voted that I thought it was materially different, because it was a legal issue.
Right. And I'm just
When we hear the timely part, because that's passed.
Correct. I mean, we
But
could
in
re-vote on
terms of
it.
materially different, there's a whole lot of things we could.
Don't open that up again.
Yeah.
We are in there.
Fair enough. I'm just.
Bill wants to proceed
I
forward,
want
which is a smart
I
move,
just
I
want to make
think,
sure Tom.
what I'm getting to is whether or not it was a legal nullity, right?
Yep.
You made a suggestion earlier that the initial violation required within 60 days for there to be a variance to be an application, and that even if you never filed one, right, filing one now upon denial of a C of O, you're still determining is it materially different to what should have been filed or what would have been filed within 60 days of the initial date. So legal nullity, my question about legal nullity in a sense doesn't matter.
It's a nullity.
Is what you suggested. I'm not saying you're right. I'm saying I'm just working through
Yeah, no, I think it really boils down to how people feel about what transpired during the interim, meaning that there was this initial application, then there was this process, and there was work which was done. Things changed, or you could say they didn't change. And did we go anywhere? And when I got these different memos, and when I saw the Article 78, I read some of the cases, and it really, in my opinion, it goes to the board. What I saw, the board has the right to determine whether they feel it's materially different. And I know that's kind of how we split this last time. I mean, it seemed like 3 people felt like the pool is where it is, it's the same. And then 3 of us felt that, well, I personally felt that I favor hearing an application. And that's a general bias I have. And that a lot has transpired. There was a judicial process. Those initial violations were discharged, and therefore this is separate. This is a new determination because that did go to the end of its cycle. But I see arguments that could be made on, like the pool's where it is. Look at it in the photo. How can you say that changed? So, but I think there has been a process which the town has been a part of, and I see it. I'd rather hear the application.
I mean, my thought process on this is that, was the application timely? And we voted yes. And I voted yes because, it was within the 60 days of the building department's determination, but also because that since the previous application was withdrawn, was this a new application? I looked at it like that. So I looked at this as the only application, shall I say, the only. So if it's the only application, then how can it not be materially different if nothing existed previously? That was my position. That's the way I looked at it. And maybe that's flawed. I don't know. I'd like to hear what everybody has to say.
You're entitled to look at it the way.
Well, that's how Tom saw it.
Because Tom argued, I thought, a good argument that if it was withdrawn, we really didn't have to
compare it to.
Right. So if we didn't have anything to compare it to, materially different from what? There's nothing for it to be materially different from.
They voted against each other, look the same.
So
there's 2 ways to look at that. Is all I'm saying. That
Right.
You can have looked at it that way, or you could say, well, it was withdrawn. So, but that's only the response to the initial determination. The initial determination still exists And is that different than the other one?
Right.
So you can look at it either way.
I could see that argument
right.
too.
So, because otherwise you could have a determination, you could have a violation issued.
Mhm.
You could fail to file an application within 60 days and then just take some other action anytime in the future that would get a response from the building department, and therefore you'd reset the clock
Exactly.
to be able to file another application.
Our
And I don't think that's the intention.
Yeah, our system wants people to go through, to determine they want to take the two paths, go to court or the three paths, really, right? Just conform right away, or the ZBA if you disagree.
Which they didn't do.
But I see the light go out of like, but so anyways, but regardless of how you felt last time, I still think this is a simple question. It boils down, it's a complex question, which boils down to whether these board members feel it's materially different. And you can look at it as compared to the initial determination, which is how I'm looking at it, and what happened in between, or you can look at it any which way you want. But I don't know if anyone has a different motion they want to make besides the simple one.
Right. And you know, and to be clear, I wish we had a straightforward path to hearing the variance. So when you talk about having a bias towards wanting to hear the case on its merits, I wish there was a clear path to that. I just can't clear that hurdle. I desperately would like to do that. I'd love to vote on a variance tonight, and then this matter could get resolved. I'm not able to clear the hurdle to get to that.
Feel it's not materially different.
Correct.
Okay.
Right.
I think it was a setback violation issued originally, and clearly a variance needed to be applied for at that time. And I don't know that there's anything that, I mean, they could, I know they've suggested that someone in the court said, don't do that, but all you got to do is walk over to the building department and file a variance request, where you were going to need no matter what happened. I just think that needed to be done.
Tom, how do you reconcile that if you thought that the first discussion on this topic was a nullity? Then how do you get to it not being materially different? What's your thinking on that?
So it's Bart's point earlier that whether or not that first application was ever submitted, there was a violation issued, right? And that violation would have required, to get a variance, would have required action within 60 days.
They could have done it at that time.
Right. So them not taking that action, and even if they had never filed the first application, this is still a replay of what they were entitled to do the first time around. I didn't come into the meeting, based on my thoughts in preparing, I didn't come in with that, but I think Bart made a good point that, and Mr. Singleton, that the violation itself, it was the opportunity to request that variance, and now we're requesting the same variance again that would have been requested then.
That's why you're thinking it's not materially different. Okay. And
I mean, there's never a question for me that the variance was necessary, regardless of the court. The original violation was a setback violation. It was 12 feet, and that needed to get resolved, regardless of how everything else worked out.
now, if the board is struggling with some of the legal issues here, we still have the option to go into executive session with town council and talk this out further and, get.
I think we're all going to come to our minds as to materially different.
Not with legal counsel, not with town council.
And I think Tom is clear in his head about this being the same. I wouldn't say that I'm 100% clear, but I do lean towards hearing the application, and I think a lot has changed in so many months. And I don't know that an application for a CO is versus the initial violation. That's only a tiny change for me.
That's not a change.
But having things removed, having a court process, having a whole bunch of other things happen, that feels different. But really, I just favor hearing the matter. And and seeing where the chips fall. And that's always what I feel like the law wants. And so the way we get there is people decide whether or not this is materially different, and we have a vote. I don't think we need any more. I tried to find good cases on point, but it basically, the board has the discretion to determine this, in my opinion, with how you feel.
And either way we vote, whether it's materially different or not, and we continue, we still have to vote on the variance.
Yeah, and we've had two
And
sides.
I may go either way. I don't know which way it's going to go.
Right, you've read the arguments from Mr. Caruso and Mr. Singleton, both spelling out why it's either materially different or not materially different. We're not going to hear any more from our attorney or from anyone else. They're both very capable in making an argument.
So, I mean, yeah.
But are you talking about two separate votes? Or
No, I'm saying,
just talking about voting?
I'm just saying
on
voting.
variance?
I'm just saying voting, and we've heard the arguments because we have two separate competent counsels who made all the arguments.
Well, we have to vote on whether it's materially different. We have to get past that hurdle.
And
So
then-
whether we're going to vote on the variance.
Yes. So there's two votes. So the first vote is, and I would like, unless we have more, I would make a motion that it's materially different.
Okay. So
We have to hear from the public first.
well, yeah, I
Yes.
want to finish hearing from the public. And also too, I mean, I'm leaning a little bit towards, I'd almost like to talk to town council further. Now, maybe I'm the exception here if the rest of the board doesn't think so.
On
I don't
what
know, what do the
matter?
other members think? Is everybody prepared to
what
make
matter?
it?
No, I don't think we need to go to that.
Okay.
You know,
Okay. What do you think, Arnie? Paul?
Well, I was hoping that there would be more information, but I don't see anything different from, throughout the entire process.
I'm always happy to take additional advice.
Melissa, do you have a position on whether we should consider going to town council on this, or we should just proceed with a vote?
I'm prepared to proceed with a vote, but I also will say initially when we voted on whether the application was timely, I voted in favor of that. If we were to revote, which I don't know if we should because Paul is present tonight and was not then, I would be voting that this is not timely.
Okay, you would change your vote.
but that vote is.
That's
vote
fine.
passed.
That's
And we would raise other issues.
To
by-
revote.
So I
Right.
I would vote not to vote that. I would vote we go to the public and see what they have to say and then put their own material.
Okay. I mean, what do you think that we should go to town? You're happy to vote with?
I'm happy to vote with. I do not think we need to.
So am I.
Okay, so it seems the majority, so Tom and I are the only ones who would seek, so we won't go to town council. Okay, so I'm going to open this up one more time for the applicant to say anything additional. And then Mr. Singleton and your client, if you wish to say anything additional, and the public, this is going to be your last shot before looks like we're going to be going to a vote. Mr. Caruso, I'll let you start. If you'd like to say something and anything further, please,
2 minutes.
yeah, please, let's try to
I won't.
be on point and succinct.
I'm not going to be a minute with this. Look, the board knows what it needs to do. Whether the origination, whether that violation back in 21 is how we got here, and whether you think there had to have been an appeal within 60 days of that violation, doesn't account for the law. The law says that material differences are things that transpire factually between two different events. As Mr. Lansky had said, we've had code violation proceedings, resolutions of them. We've had improvements to the site, removal of encroachments, a building inspector determination denying the C of O, and this application. Any one of those is a material difference. It's not trivial. Those are real things that happened. People were on site working. People made decisions. Things happened between that first violation back in 21 and what you hear tonight on, regardless whether the application was withdrawn, whether you agree it's a legal nullity or not. The law says if there are material differences, you can hear it. That's what we're asking. Thank you.
Thank you. Mr. Singleton, do you wish to say anything further in regard to this application?
Yes, material differences on the Woos property. There are not material differences on the Woos property. As your board has noted, it was 13 point something feet. I'm sorry, it was 3 feet from the 2 or 3 feet from the property line before. It's 2 or 3 feet from the property line now. They haven't changed anything on their own property. The encroachments on the Stancia property are irrelevant to their application. A substantial change in the application is the application to the Woo property, not the Stancia's property. I understand and appreciate, I'm sorry if I mispronounce your name, Ms. DiPolito's position. I do think that the application is not timely in light of the fact that you've now discovered, and I've supplied you with information, that a requisite element of the application was not submitted. They did not provide the certification saying that there were no violations on the property, and I understand why she would vote differently today. I really don't see how anyone could come to the conclusion that a pool in a location that has not changed, proposed to be changed, or anything associated with it proposed to change is a different application when they're proposing to keep it exactly where it is. To me, I can't believe we're even at this point. I would like to just point out one other thing. I know it's not something that your board discussed. I think, and I'm pretty confident of my position, that your board is without jurisdiction. As I've said in my letters and I've said in these meetings, I strongly encourage you to get the advice of counsel, because it is unequivocal in my mind and under the law that your board has no jurisdiction to act on this application. And I'm very surprised in Jerry's determination with regard to whether or not there's a pending violation. There, under the law, there certainly is. And under your code, you can't hear the application. And to ignore that component of analysis in your discussion, to me, is dangerous. I appreciate the fact that you want to hear the application. It's always good to decide things on the merits, but to me, it's unequivocal that you don't have jurisdiction here. And I would hate to see your board act in excess of its authority.
Okay, thank you, Mr. Singleton. Mrs. Wu, would you like to speak in regard to this issue?
I would like to say a little something.
Sure, absolutely.
I would like to say, yes, we did a lot of construction on our property. We took down pool decking. We did a lot of work. To say we did none is absurd.
You're talking about since the violation was issued in removing what was there or some things. Yes.
Yes. I feel I've been to a few of these meetings and I've seen that other Somers residents come, they put in an application, the board hears them, and then you make a decision. If you noticed, we have not been able to speak. Every time we come here, we have been blocked by misinformation. And all I ask is that you please vote to hear our case. Where else would we go for jurisdiction? Where else would we turn to? We would love for you to please give us the courtesy, with all due respect, like other Somers residents that come before you with a variance, to hear the whole case and not just one side. Thank you.
Okay, thank you. Does anybody else wish to speak in regard to this application? Mr. Stansky, please come up. Oh, please go to the microphone. We have to hear you at the microphone. And just give us your, I'm sorry, give us your name and address.
Sorry, my name is Panta Stancho. I'm for Silver Spring Court.
Yes.
So I shortly want to make.
Yes, please.
The beginning of May used to be very strong storm, 4 days rain. I have a picture. The water comes on my property because whatever they did, they protect their property, their pool, not to get flooded. My house and my property is flooded. That's going to cost me hundreds of thousands of dollars. If you approve this pool, you're going to be part of those hundreds of thousands of dollars of my property damage. I have pictures and You should come. I called Tom to come when we had flood before, and he saw it. He walked away like a little rabbit. And he approved the pool. He signed the papers illegally to make the pool to dump my property.
That's not an issue before the board.
I had to say, you want to see the water, how it's coming?
Panta,
He's entitled to public comment.
Okay, I'm
Whitney.
sorry. I'm sorry. I don't have, you guys do what you guys think that you want to do tonight, but it's not gonna end. I spent already 40,000. I have to spend more, and you guys gonna be part of all those expenses because I don't make this problem. They make the problem. I came there like a neighbor, clean, and I told a family, like a family, not to have this kind of problem, to spend hundreds of thousands of dollars. For what? To protect my property. And they enjoy. I
Okay,
think.
thank you. Thank you. Okay, so I think that's going to conclude public comment. Any further discussion the board wants to have before we go to a vote?
I do not.
Okay, so just to kind of logistically figure out what we're doing here. So it seems like we're going to possibly entertain a motion or a vote on whether it's materially different.
Yep.
If it's not materially different, then that ends it. If it's materially different, then we will discuss the variance.
Yep. So I would move that this application is materially different, and that we can hear the variance application.
Okay, so you're making a motion that it is materially different to
Yeah.
hear the application. Okay,
You want a second, Tom?
okay. Do I have a second on that? Do we have a second from anybody that's materially different?
No. Doesn't look that way.
I'm gonna second it.
Okay.
All right, so Denise?
Denise,
Denise,
you're
you're on
muted.
mute. I'm sorry, yeah, Denise is on mute.
Sorry, Ms. DiPolito.
Nay, no, it is not materially different.
Mr. Gio,
Nay.
Mr. Harden,
Nay.
Mr. Lansky,
Aye.
Mr. Newman,
Nay.
Mr. Padavani,
Nay.
Chairman Canestra.
Aye. So the vote is 5-2. The application is not considered to be materially different. And that ends the matter before us. We're not going to hear the variance. Okay. Okay.
Chairman and board, regardless of your vote, I just wanted to, I get a little heated at times. I'm half Irish, half Italian. So I apologize if I get a little heated at times, but thank you for your time and consideration.
Okay, all right, okay, thank you. Okay, so this ends the Wu application at this point in time. Next item on the agenda is a review of the meeting minutes dated May 16th, 2023. Has everybody had a chance to review those minutes?
Yes.
Okay, any changes, issues, concerns? No? Okay.
No.
So why don't we approve them by voice vote? All in favor?
Aye.
Anyone opposed? Any abstentions? No, okay. And last thing I had on the agenda was just to make note that our next meeting is July 18th, 2023, third Thursday in July at this location. Our meeting this month is 1 week earlier because I believe tax certs are in here next week. So that's the reason we met early this month. Any other discussion points, questions, issues, anything else we have to cover?
Not this time. I'm good.
Vic, excuse me,
Yes.
may I just ask a general question of everybody? Generally, we do not meet in August. And I probably have 6 to 8 pending applications that have now missed the July deadline. Which means if we don't meet in August, we can't hear their applications until September. Some of them are construction based, they can't move forward on a project until they get a variance. I don't know, I don't have a calendar in front of me with the third
August
Tuesday.
15th.
August 15th. I mean, I feel like, we've always said if we don't have anything going on, but we have quite a bit that's pending. And the next meeting is August. Can we have a meeting in August?
Well, the main issue we've had with August is that a lot of people schedule vacation. So I don't know if people know their vacation schedule yet.
I'm available.
I'm available.
I am not.
Okay.
I'm available.
Are you available, Tom?
Yes.
Okay, so we do have, Melissa, are you available August 15th?
Yes.
Okay, so it seems like we have a majority of the board. I'm not sure if I'm going to be available, but that's only 2 members that might not be available. So you would still have a quorum. So Denise, then maybe we should keep the meeting on the calendar. I'm not sure if I'm going to be available yet, but okay.
Okay, I would prefer to keep it on the calendar if we could. And not to have to push these people off now until September. But we'll see how it goes. All right.
Okay, so
Let's
for
see how
right
it goes.
now, I think the meeting is on. We've had at least 5 members who will be available. You need a minimum of 4, obviously. So let's then schedule the meeting for August 15th.
So it was Vic, you're a question mark. And who said that they're not available, Paul?
I'll be in South Carolina for August.
Paul,
Okay,
If I
Paul.
could Zoom in, I would do that. I don't know what the rules are.
Yeah.
I won't be.
Well, let's
anywhere
see what
close.
happens. 2 months away, a lot could happen. If that is an opportunity you have, I certainly will let you know. You don't count toward the quorum at that point, but you can vote. But let's talk about that offline.
Okay.
All
Okay.
right?
All
Okay.
right. Sounds very good. Any other issues or items we have to discuss?
No, I'm good.
Nope.
Not yet.
Nope.
Sure.
Okay, so I think we're going to wrap up the meeting then tonight. Thank you, everyone, and have a good evening, and we'll see everybody next month, July 18th, 7:30. Good
All
night.
right, thank
Good night.
you.